Court calls the case People versus Eric Coons.
Stephanie Can on behalf of Mr. Coles, who is
Oh,
appearing to my
you're
right.
actually going to do something today besides take credit for Miss Apple's victories.
The honor is all for one here, all for one.
Yeah,
Please state
they
your
don't
name.
think that way when you what you do. All right, I'm just saying. Your name, sir?
Eric Coon.
Thank you.
Your Honor, I do believe you should have a green sheet for Mr.
I
Coles.
do.
We're just asking for a 2-week adjournment in this matter. There's normally having sheets, so sorry.
May 15th. Turn it out a little bit longer than that, okay?
Okay.
Preliminary or probable cause conference, May 15th, 2025, 9 a.m.
No problem.
All right. Bond will continue, sir. Thank you.
Thank you so much, Your Honor.
Court calls case People versus James Richmond.
Alexander on behalf of the people. Hannah Apple appearing on behalf of Mr. Richmond. No. Mr. Richmond, will you state your name for the record?
Hi, my name is James Richmond.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
You have all discovery.
Yes, Judge.
People have their witnesses available the 6th.
Yeah.
Preliminary examination in person, May 6th, 2025, 9 a.m. That before Judge Perry. Bond will continue. Thank you. Court does call the case of People versus Sanders. Quinard.
Public defender on behalf of Mr. Sanders. Your Honor, state your name, Mr. Sanders.
Quinard Sanders.
Thank you.
Your Honor, we're going to ask the court to set this matter for an exam.
Discovery is complete.
Yes, Judge, as far as I know.
People have their witnesses available the 6th. Preliminary examination in person, May 6th, 2025, 12 noon. That's before me.
If I can be heard on bond, Judge.
Sure.
Your Honor, Mr. Sanders is here. He's he has an exam schedule, obviously. He is a local resident. He's not a flight risk in any way. He has missed some court. It was some of it was due to a medical situation that is ongoing here in the jail. He reports that he hasn't been able to get the kind of care he was getting on when he was outside. He has a issue with his lungs. There's certain medications that he does take that are not available to him here. Now,
What do you mean they're not available?
well, the jail has not made them available. I don't know if they're prohibited from being in the jail or if they just haven't gotten them yet or are able to get them. He's missed medical appointments. He has, I've instructed him to kite those, I don't know if he's received any responses. Also, I'm not going to gild the lily. He does have a MDOC hold. I have reached out to his parole officer. She was not the most forthcoming about what would happen. It's my understanding they have 4 days after he's not being held here to submit a report, and then it goes to the supervisor there who makes a decision as to what they are going to do. But I don't have any knowledge as to that. I've reached out to the supervisor as well and have not. I talked to him yesterday, but he didn't have any information for me. But he is local. He's not a flight risk. He has a place to stay.
I don't need a response. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Ronald Sims.
Assistant Public Defender Davia Lebo on behalf of Mr. Sims, who stands to my right. Mr. Sims, can you state your name, sir?
Ronald Sims.
Thank you.
And Your Honor, we'd like to set this matter for preliminary examination, please. We do have complete discovery.
People have their witnesses available the 6th. Preliminary examination in person, May 6th, 2025, 9 a.m. Is that right?
Yes.
9 a.m. before Judge Perry.
Thank you, Your Honor.
Bond continued. Thank you. Court recalls the case People versus Brendan Chrysler.
That's a lot of people.
James Butfelski on behalf of Mr. Chrysler. Fortunately, he has not been able to get here. I did talk to him on the phone a couple of times. He's stuck in Flint and he has not been able to get transportation. So I'm asking for a 1-week adjournment. And that's all I have to say.
Your Honor, has the court received the community corrections report?
Yes.
He's missed his last 2 tests. People are requesting bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of 25,000 cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor. Have a good day.
Court calls case People versus Dominique White.
And then on behalf of people, second again on behalf of Mr. White. Mr. White, in your presentation into the record.
Dominique White, Your Honor.
Your Honor, we're just simply asking for a preliminary exam in this matter at court's earliest convenience.
You have all discovered.
Your Honor, I do believe that we have everything.
People have their witnesses available to 6. Preliminary examination in person, May 6, 2025, 12 noon before me.
Thank you. Your Honor.
Continue. Thank you. Court calls the case People versus Danielle Lamadin. Admitted.
Carolyn Foster Tucker on behalf of Danielle Lanesman.
That's what I said. Okay.
Your Honor, I was informed this morning that she is in the hospital and is not here today. I would just request a 2-week adjournment.
Without objection, I'll grant the adjournment in this case. She'll be adjourned to. Sure. Make it May 15, 2025. 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does recalls the case of the People State of Michigan versus Quinard Sanders.
On behalf of people. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Sanders, who's here to my right. State your name, Mr. Sanders.
Quinard Sanders.
Your Honor, thank you for calling this case. I wanted to clarify something that when arguing bond, I had said Mr. Sanders had not appeared in court because of his not being well. I'd like to point out he was in the hospital. In fact, I think the February PCC was adjourned based on that. I do have a letter to that effect. He was a victim of a stabbing, and then later his lung collapsed and he went back to St. Joe's. I don't have any clarification as to that right now, but we can certainly endeavor to get it if the court would like to see it. But he does report that he did contact our office about that. In terms of the medication, he's not able to get it's a pain patch, which kind of makes sense, which explains it. And again, I have contacted parole about this matter a couple times, and I was able to speak to the supervisor once, who instructed me to call him back again at 8 in the morning, and I did, and it didn't work out. But it's Mr. Sanders' understanding that if he is released, he will get put on a tether by MDOC and reinstated on parole, with his discharge date being backed out to February 26th. But I'm not able to verify that. But that's his understanding as well, and
That's his understanding, but they haven't verified that's what they're intending.
I have not been able to verify that. He reports that his family member, his mother, has spoken to the parole supervisor, Chase Dazelle. I believe is how you pronounce his name. And that's his understanding. And he does have a place to reside, Your Honor, which is here in town on Gulf Side. I just want to make sure the court had all that information.
Yeah, some of that is a bit different than court reception, but overall, it would not change the court's view of whether or not to reinstate the defendant's bond or to do something different. I appreciate the clarification. It's the court's decision that the defendant's bond will remain the same so that the motion is denied.
Your Honor, one thing came to my attention. Since we passed the matter, I had sent an email to the Ypsilanti police officer who's involved in this case. Has already responded that he is out of town on vacation. That we set this exam, we set it for May 6th.
Yes.
I don't know if the court would entertain right now my request to bump that 1 week in light of that information. But it doesn't appear that we will be able to proceed to exam on May 6th due to his own availability. And this is a single witness exam.
Well, he's got the parole hold anyway, so I'm gonna put it to May 13th,
Your Honor,
1
Yes.
week out over the objection of
Would that be for the 13th?
yeah,
13th at 9. That still would be before me.
and we would object to the move, Your Honor, but in terms of his bond or his exam date's moving out, if we are able to ascertain some more or obtain some more information, from St. Joe's about his hospitalization, I'd ask the court to consider a motion to.
Yeah, I mean, and it could be done one of two ways. You can either send the information to me for my consideration, or if you contact my office and would like it scheduled when on a PCC day. So for me, that's going to be the 1st to 6th prior to this 13th date. Certainly, I would entertain hearing it depending on what the docket looks like.
Thank you, Your Honor.
Thank you. Court calls case People versus David Lee Furman. Madam Attorney General, if you could take your appearance, please.
Yes, good afternoon. Assistant Attorney General Clarissa Williams on behalf of the people.
Good afternoon, Your Honor. Edward Drukas on behalf of David Furman.
Mr. Furman, can you state your name, please?
David Lee Furman.
Thank you. He shut off his camera, but I saw him. All right, what are we doing?
Your Honor, there might be a nollie press in the file.
Is there? He did tell me that there was, okay. So this case is being dismissed. All right, case is dismissed. That's by Nally Pross. Court has signed that. Thank you, folks.
Thank you, Your Honor.
Thank you,
Your
Mr.
Honor.
Furman.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Jacob Jackson. It's also an Attorney General case.
Good afternoon, Laura Yagi, Assistant Public Defender with and on behalf of Mr. Jackson. Mr. Jackson, could you unmute yourself and state your name for the court?
Jacob Jackson.
All right, what are we doing?
Your Honor, Mr. Jackson and I discussed waiving his preliminary examination. Unfortunately, because he's on Zoom, I don't have a signed waiver. I'm wondering if the court
Is he
would be-
gonna waive? He wants to waive?
Yes, Your Honor.
Mr. Jackson, is that correct? You want to waive your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Ms. Yagi.
We would waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 17th at 1:30 p.m.
Judge who? June 17, 2025, 1:30, Judge Conkey. Bond continued. Thank you.
Thank you.
And I think I have one more for you, Madam AG. Court does call the case of the People versus Joseph Wynn.
And Laura Yagi, Assistant Public Defender with and on behalf of Mr. Wynn. Mr. Wynn, can you state your name for the court?
Joseph Wynn.
Yes, Ms. Yagi.
Your Honor, I am asking for an adjournment in this matter. Mr. Wynn and I have been in communication, but we are asking for a little bit more time for me to look into a couple things and for him to get set up online with the payments.
All right. That objection, I'll adjourn probable cause May 15, 2025. 9 a.m., or as your invite indicates. Bond will continue. All right, thank you.
Thank you, Your Honor.
Thank you.
All right, thank you. I think that's it. Madam Attorney General. Court does call the case, People versus Armani Taylor.
Good afternoon, Your Honor. Sydney Rushing appearing on behalf of Ms. Taylor. Ms. Taylor, can you please state your name for the record?
Armani Taylor.
Thank you.
All right, what are we doing?
Your Honor, we're asking for a brief adjournment so that way we can receive discovery.
Say that again. I don't know what's happening with my speaker.
Your Honor, we're seeking an adjournment so that way we can receive discovery and review it.
Probable cause conference, May 15th, 2025, 9 a.m., or as your invite indicates, bond continued.
Thank you so much, Judge. Have a great day.
Thank you. You too. Court does call the case of the People versus Harold Martin. Ms. Plumai.
Your Honor, Alexis Plumai appearing on behalf of Mr. Martin. And there's no Mr. Martin in the courtroom. Your Honor, I have not been able to get in touch with Mr. Martin. Unfortunately, I don't have an explanation for his absence. I don't believe he's here today. Harold, no, Harold Martin. So Your Honor, I would.
This be your case? You know, if you want to be your case, let me see what you're charged with. I don't know if you want all this, but well, I don't know.
I would ask for an adjournment. It looks like our office had contact with him just a couple weeks ago. But I haven't been able to reach him this week.
Your Honor, the defendant does appear over a year ago. The warrant was recalled recently, but it's not here today, so I request warrant issue.
Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety. Warrant will issue immediately. Court does call the case, People versus Larry McCullough Hawkins.
Alexander, on behalf of the people.
Lord Yagi, Assistant Public Defender with and on behalf of Mr. McCullough Hawkins, who is approaching. Did you state your name to the court?
Thank you.
In this matter, Your Honor, I do believe we have discovery. There's a 911 call that's en route to our office. So I would respectfully ask that this matter be set for preliminary examination.
$911 call.
That's correct. It was uploaded yesterday, so it should be here by Monday.
People have their witnesses available to 6.
We'll try our best.
Preliminary examination in person, May 6, 2025 at 9 a.m. with Judge Perry. Bond continued. Thank you.
All right. Thank you, Your Honor.
Calls case, People versus Charles Meade. Mr. Feaster.
Yes, Assistant Public Defender Tanazi Carey, I can rule, Your Honor, on behalf of Mr. Charles Meade.
Let me go find her.
At this time, people will be moving to dismiss this case without prejudice, we'll file a knowledge process based on competent and not restorable.
Any objection?
No objection at all, Your Honor.
Case is dismissed.
Thank you, Judge.
Thank you, Mr. Meade.
You're welcome, Your Honor.
Calls case, People versus Jeffrey Moore.
People move matters.
Assistant Public Defender Davi Leave on behalf of Jeffrey Moore stands to my right.
Jeffrey Moore. Thank you. What are we doing?
And Your Honor, we'd like to be setting the 0206 matter for exam and adjourning the 0707 matter to track along with it.
You want me to do what?
Your Honor, I'd like to set the 206 matter for exam and adjourn the 0707 matter to track that other matter,
To track what other matter?
the 0206 matter.
So you want an adjournment on 20?
On 707, Your Honor.
You've lost me, counsel. I'm just trying to figure out what you want done with these cases. Do you want one of them set for exam?
Yes, Your Honor.
Which one?
206.
Is all discovery on that complete?
It, Your Honor.
People have their witnesses available to 6?
We'll try, Your Honor.
In this case, preliminary examination will be set for May 6, 2025 at 12 p.m. noon. That's before me. That's in person, bond continued. Now, what do you want done with this other one?
Under the other matter, I just want to adjourn to a date approximately around the same date as the exam. As how we're proceeding in that case may depend on how the
It'll
exam.
be the same date. It's in the morning now.
Thank you, Your Honor.
Probable cause conference, May 6, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you. Court calls case People versus Victor Morris Gerard.
On behalf of Mr. Correct, state your name for the record.
Victor Morris, Sheriff.
Your Honor, in regards to the probable cause conference, we're requesting an adjournment. There was still some outstanding discovery that we requested.
You have a green sheet? No.
That's a no. I've got it right here, though.
I don't mind it now, but we do have a problem. 2025. As to the bond violation.
As to the bond violation, and I did have an opportunity to speak with Mr. Gerard. Your Honor, he takes full accountability. He's indicated to me that he has been struggling with depression, and obviously, now knowing that this issue is much bigger than we talked about treatment opportunities. In the report from they did indicate that they have made a referral for CCOP on his behalf as well. He has not spoken with Mr. Brown to see where they are with that program, but I just asked the court to at least give us the opportunity to explore that option and see if we can get him into outpatient treatment.
No, you might be able to get him into outpatient treatment, but he's clearly in violation because they have had 4 successive tests where he's positive for cocaine, amphetamines, and then his last test positive for cocaine and alcohol. But before the confirmation test on the alcohol, he left the building.
And I did ask him about that, Your Honor. I think that was just a misunderstanding. He stated that he did not know that they needed him to stay in the building to do any other follow-up tests. But I've explained to him that once there is a positive alcohol test, that they require the confirmation test.
All right. Anything else?
Nothing else.
So I set it for May 6, 9 a.m. But at this point, defendant's bond is revoked.
Thank you.
Court calls case People versus Justin Robinson.
Agenda on behalf of People.
Good afternoon, Your Honor. Assistant Public Defender Carson Bovesi on behalf of Mr. Justin Robinson, who's present to my right. Mr. Robinson, can you state your full name for the record, please?
Justin Robinson. Thank you. What are we doing?
Today is the date and time set for a PCC. We'd be respectfully requesting to set this for a preliminary exam at this time.
Well, discovery complete.
To my knowledge, yes. We would ask for the earliest date available.
People have their witnesses available to 6.
We'll do our best.
Preliminary examination in person will be set May 6, 2025.
9 a.m. before the hearing.
9 a.m. before Judge Perry. I will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Mountain Rucker.
Kevin Adish on behalf of Mr. Rucker. Assistant Public Defender Kevin Adish now officially. Can you say your name for the record?
Mountain Rucker. All right, sir, you need to take your hand out of your pocket, please.
You can take your hand out of your pocket.
Are you having problems hearing me at all?
I'm deaf in this ear.
All right, hold on, we'll get you.
They're gonna give you that. Thank you.
See, we're a team.
Yeah.
Together.
That's not a team thing.
She can get,
That's you being in everybody's business. That's all that is. That doesn't make a
you
team.
know, whatever the outcome, you can get all credit.
She's just in everybody's stuff. Does that help you, sir?
Yes, sir.
Okay.
All right.
Your Honor, we're gonna be asking for an adjournment. I hadn't been able to get in contact with Mr. Rucker. It is because he isn't able to have a phone based on his bond conditions. I was going to request that he be able to buy a flip phone and use it, one that does not connect to the internet. That way we are able to talk to him about his case.
Oh, I see. People have a position on this.
Does he have no bond condition that says no phone use, or is it no using a device?
That's the internet connection.
So he's able to.
Device.
Okay. Okay. We'll talk about that later.
Where do you get a flip phone? Never mind, my bad.
From somewhere, I don't know.
What?
I can Google it. I'm not sure right now. I have one in my room. No, it's my old one.
You are not old enough to have
How
had
would
a
you-
flip.
It's not, it technically, it slides, it doesn't flip. It slides.
You are not old enough to have a true flip phone. I'm just telling you right now.
All right. I'll get rid of it.
People stopped using those probably when you were about 2.
That's so funny.
All right.
All right.
I'll adjourn this to May 15th, 2025, 9 a.m. If you arrange for the flip phone or the non-phone, what I'm going to suggest you do is at least take a picture of the packaging and maybe the serial number above it so that there isn't any miscommunication. Get that to the prosecutor.
Definitely.
Okay.
Thank you, Your Honor.
Thank you. Bond continued. Thank you, sir.
Thank you.
He's got it.
I'll take your honor.
No, it's okay. See,
Great.
Ms. Cannon was all in the business and everything until it came time to, no, you show back up. Now she's not all up in. Court calls the case People versus LaDonta Skinner.
Assistant Public Defender Jay Bellinger on behalf of Mr. Skinner, who approaches.
Good afternoon, Your Honor.
Good
LaDonta
afternoon.
Skinner.
Thank you.
Your Honor, we're just seeking to set for preliminary examination on this.
Ready. Better be bringing the track shoes May 6th. Discovery is complete.
Yes, Your Honor.
People have the witnesses available May 6th.
We'll do our best, Your Honor.
Preliminary examination in person, May 6th, 2025 at
Well, yeah, before you.
12 noon before me. Bond continue.
Thank you. All right, we'll be in touch, okay? All right.
Court calls the case People versus Ira Smith.
Jennifer Douglas. Stephanie Cannon on behalf of Mr. Smith, who is not present, Your Honor. I would just ask for a show cause. I'm just asking.
Really?
I'm just asking.
You got that from Daddy, didn't you?
He's
That's probably this team thing.
my hero.
Did you ask him when you got that from him how well that works?
How well does it work for you?
What?
Does it work well?
There's no saying if you don't ask, the answer's always no. The answer's always been no.
Bench warrant will issue for defendant's failure to appear Bond 10,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Was that a whole team thing too? No, nobody else was like. Court calls the case, People versus Virgil Stafford. Stafford. Excuse me.
Madam Prosecutor. Stephanie Cannon on behalf of Mr. Stafford, who is also not present, Your Honor. However, I did provide this court with confirmation that he is currently hospitalized at Havenwood Hospital. I've given it to Madam Prosecutor as well. We're just simply asking for an adjournment of this matter. And I do believe there is a green sheet that should have been provided.
But you don't know.
I mean, I feel confident in your staff, so I'm gonna go with yes. Good answer.
In my staff?
Good answer. Good answer. I gave it to Ann. I did, I promise. Oh, cool. Yes. Good answer. Good answer. Okay.
She had no idea.
I did. So Your Honor, I'm asking for a 2-week adjournment to give me the opportunity to speak with him to see how we're going to proceed on this case.
May 15th, 2025.
Thank you, Your Honor.
And the bond continues. Thank you. Court does call the case of the People versus Derek Stewart.
And Your Honor, Alexis Pluma appearing on behalf of Mr. Stewart, who is in the vestibule right now.
Wait, did you? Which one?
It's Derek Stewart.
Yelling. Who's that yelling? No, who was yelling? Why were you yelling?
I didn't hear the first name.
Talk about.
And Mr.
everybody's
Stewart,
business.
could you state your full name?
Thank you, sir.
Your Honor, our office has received a copy of the competency evaluation in this matter. Have gone over it with Mr. Stewart, and we are not objecting to the findings of that report.
I am objecting.
That the defendant at this time is incompetent to stand trial, but with treatment would likely regain competence within a statutory period of time.
Yes.
Any other additional evidence from either side?
No.
I need a 3 months because. Excuse me. Set a review, competency review hearing July 24th, 2025 at 9 a.m. Counsel, you'll prepare the requisite order.
Yes, and Your Honor, if I could briefly address bond.
Yes.
So I, for whatever reason in OnBase, I'm not able to find the most recent community corrections bond order. But Mr. Stewart is on some kind of a GPS tether at the moment. I'm not sure if it's just tracking or if it's an exclusion zone. That is both very uncomfortable for him, and because he currently doesn't have housing, it's very difficult for him to make sure that it's charged to get somewhere where he can plug it in. I will note that he has been, at least the last few times that I've represented him, he has appeared on time for court. Nothing, nothing by way of new offenses. He's compliant on bond. He would just ask Your Honor to consider removing that tether.
Any response from people?
Your Honor, I understand it may be uncomfortable, but unfortunately, the nature of these allegations seem to require it. Mr. Stewart is charged.
I'm disabled. What am I?
Pay attention to the jail.
It's your world, I'm just in it.
May I continue?
Go ahead.
The nature of these allegations appear to require Mr. Stewart is charged with 1 count of witnesses bribing, intimidating, and interfering. Essentially, the allegations in this report describe Mr. Stewart. These are physical confrontations in terms of rushing this individual in this area. Now, him no longer living, I think, close by may assist with that, but I don't have any assurance that Mr. Stewart is going to be able to essentially not contact this person. I might feel differently if we were dealing with text messages and emails and phone calls and that sort of thing. These are physical confrontations.
Your Honor, I do believe Mr. Stewart is no longer living at that location. This incident occurred back in 2022. At the time, I believe Mr. Stewart was still at that apartment complex. He had since been evicted and isn't staying there anymore. It's my understanding that you are usually in downtown Ann Arbor, or Delano's Center as his mailing address. Okay, but either way, I don't think he plans to or has been going back to that location.
Well, you evicted me, why should I go back?
All right, the original order, that's what may help, is at least as I see it, the original order was back on September 21st of 2023. However, there was a period in time at which, for whatever reason, as it was proceeding, it came through, and then I think at some point the defendant bench warranted, and there were some other issues. At later date, I then set aside the bench warrant, reinstated his previous bond conditions, which is why he has the tether on now. Okay. So I'm a bit reluctant. Well, what I'm going to do is this. I'm going to deny your request at this moment. And what you would need to do is file a written motion that I can consider fully as to the release, where he is, and lay all of that out to me. So at this time, the motion for bond modification is denied. Thank you.
Okay, thank you.
Bond will continue.
24th of July.
Huh? Oh, is that what it is? Okay. I don't know what it is. Okay. Court calls the case, People versus Elijah Stewart.
Deputy Your Honor, Jacob Kennedy on behalf of the people.
And on behalf of Mr. Stewart, who is appearing to my right. Mr. Stewart, when you are present, please state your name for the record.
Is Elijah Stewart.
Thank you. And Your Honor, we're simply asking for a 2-week adjournment of this matter for
You didn't know?
some additional investigation. No, yes.
Probable cause conference will be adjourned May 15th, 2025, 9 a.m.
And Your Honor, if I may, could you please remind the defendant that there is to be no one having third-party contact with the victim in this case?
Why am I reminding him of that? What do you have?
Kind of my understanding, he has been having some contact with the victim.
Whatsoever.
Stay facing forward.
Your Honor, this is the first I'm hearing about this. I've spoken to my.
I don't even know what it is. So what are the specifics? I mean, because I'm not going to admonish somebody if they're not doing anything.
Thank you.
Oh, you were going to sign on to it like I care.
That's funny.
No.
My big advocate informed me that someone's been coming to the victim's house. We don't have any information as to who that's received.
That's attached to him?
It's unclear at this time. We just want to make sure that no contact is happening.
Well, I think he understands his bond conditions, but I don't even see that it's remotely approaching any type of bond violation. I'm not going to admonish him. I'll
Thank you,
wait
Your Honor.
until you give me something that I can do. Bond will continue. Thank you.
Thank you, Your Honor.
All right. Right, okay. So I don't know. I don't have any information. Court does call the case of the people versus Cynthia Subtle.
APA Rachel McDuffie for the people.
And Assistant Public Subtle statement for record once you approach.
Cynthia Subtle.
All right, what are we doing?
Your Honor, we have we've come to a resolution in this matter, court and advice rights form, as well as the sentencing judge waiver. If Ms. McDuffie can offer on the record.
Well, I'm not, okay. I can get back one step. Miss, my apologies, Miss Soto adjourned. Okay, I didn't know if you were waiting for this.
No, I don't know what, I'm just, go ahead.
Miss Soto adjourned last time so that she could make one last payment to complete her restitution payments to get the misdemeanor offer in this case. Ms. Soto did in fact make that payment, but it was extremely recently, I think within the last hour or so. So I did let Mr. Carriac really know that I was not going to be able to get a plea form filled out before the case was called.
I apologize. I must have misunderstood her, Judge. I thought she said that she would get the plea form filled out before the case is called, after we confirmed that the payment was made. That's my apology. I literally missed the word.
I'm glad that communication is working so
It's
well.
not.
So if the court is willing to pass the matter.
But I
No,
If not, we can.
no, I'm not.
Okay.
I'm sorry. I would normally do it, but
Okay.
you can blame that person standing next to you. Wow. Wow. The funniest thing is I've never seen Akron really move that fast. Anyway,
Okay, so we're obviously.
why don't I just put it out to the 6 in the morning? Okay,
In the morning.
so probable cause conference, May 6, 2025,
Okay,
9 a.m.
okay.
Bond continued.
All right, thank you so much, Judge. I'm sorry about that.
Thank you.
Court calls the case of the people versus Troy Swope.
For those are people.
Assistant Public Defender Chinazi Carriac Rule, you're on behalf of Mr. Troy Swope. Don't you was in here a moment ago? If I can just check for him in the hallway.
Sure.
Swope. Maybe have a green sheet for Mr. Swope. Here, and I'm handing the court a green sheet now. We're asking for an adjournment in this matter. Mr. Swope has been having some medical issues, so he was in and out of the hospital. Well, he was in the hospital. We weren't able to have contact with him. Obviously, he's here. I'll confirm his contact information and see if we can figure out what's going on this case and come to a resolution with the people. We are in communications with them in regards to a resolution, but we have not been extended an offer yet.
Go ahead.
Your Honor, we think that before we get to an adjournment, we should perhaps address bond. There was the violation report sent out indicating that Mr. Swope was released and on April 12th. And that he was supposed to be reporting to community corrections, which he never did. He did not go to community corrections for intake, let alone the 2 times a week testing that he's supposed to undergo, Your Honor. My understanding is that Mr. Swope did not appear to have money, Your Honor. So it does not appear that there is a legitimate reason for Mr. Swope not showing up. At the very least for intake, he will be putting up more to pay for some particular tests. And my understanding is that he'd still be able to test, he just might end up owing some money. So Your Honor, at this time, I believe that Mr. Swope is in violation of his bond conditions and that perhaps a would be appropriate. It's good that he came today. However, we have no idea whether he's been using substances during this time. He's been out or why he did not even show up for anything.
And Your Honor, I did have a conversation with the people in regards to that. She did ask what the reason for his failure to report was, and everything that she stated is correct. I spoke with Mr. Swope. He stated that he did not have any money and he thought that he was required to present money at community corrections. Now, if there's a change in the rule, I did tell him that we still encourage our clients to go and form community
He needs to
corrections.
go.
Yeah.
He just hasn't done anything. Is he working?
No, he's not, Your Honor.
If I were to test you right now, you're gonna test clean? Don't, you're not. I didn't think so. Mr. Adams. Your adjournment. I'll set this probable cause conference for May 6th, 2025, 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Court does call the case, People versus John Terry.
Your Honor, Alexis, am I appearing with and on behalf of Mr. Terry, who is approaching? Mr. Terry, could you state your full name?
John Martin Terry?
Oh, I would have taken the other charges. No, I'm kidding. Go ahead.
Your Honor, we are just asking for a brief 2-week adjournment. Mr. Terry is receiving some treatment. He's just gonna get some letters from his providers to give to the prosecution as proof.
Oh, is that correct, sir?
Yes, sir.
All right. No objection from the people. How much time did you need? Did you just say you want the 15?
2 weeks, is that the 6th?
I don't know.
I don't know either.
12 days out. So I don't have the 8th, which.
Oh, okay.
So you can have the 6th or the 15th, which is gonna work better for you.
15th.
Of course I need that. Probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Thank you, sir. Let's call the case, People versus Delco Thomas.
Thank you, Your Honor. Constable Basin on behalf of Mr. Delco Thomas, who's present to my right. Can you state your full name for the record, please, Mr. Thomas?
Delco Thomas.
Thank you.
Your Honor, today is the date and time set for PCC. At this time, requesting a brief adjournment. There is some additional discovery my client wants to provide me that I would like to take a look at
with him. Okay, probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Herma Dadich on behalf of Mr. Veraldi appearing on Zoom. Mr. Veraldi, can you state your name for the record?
Louis Veraldi.
All right. We're not.
Your Honor, we have come to a resolution with prosecution, but we are going to be asking, sorry, I confused. That's my bad. We're going to be asking for an adjournment because we need to continue plea negotiations with prosecution.
Got it.
Yeah, that was another thing.
Okay. That's because you've been hanging around Cannon. I'm just saying that will happen to you. So what we'll do, probable cause conference without objection. I'll adjourn this to May 15th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Continue.
I'll talk to you, Mr. Veraldi.
Thank you.
Court calls case, People versus Jelani Wright.
Jennifer Douglas for the people.
Assistant Public Defender Davi Lee on behalf of Mr. Wright, who is approaching from my immediate right.
Thank you.
And we're going to be requesting an adjournment today. We have reached a resolution in this matter, however, that requires the upfront payment of $1,000 by Mr. Wright, and he's going to be needing a couple weeks to come up with some money.
Okay. How much time are you gonna need?
2 weeks, Your Honor.
I was asking him. Is 2 weeks gonna work for you?
Yes, that's what I told my lawyer.
Okay, but is that gonna work for you?
Yes.
I don't. Probable cause conference, May 15th, 2025, 9 a.m. Give you a little bit more time than that. Try to make sure it gets done. Okay. Thank you.
Thank you, Your Honor.
Court calls case, People versus Roman Whitfield.
Jennifer Douglas for the people.
And Assistant Public Defender, Your Honor, on behalf of Mr. Rowland. State your name for the record, please.
Roman Whitfield.
Judge, I do have a green form.
I do not.
I have a green form to submit to the court. I didn't finish.
Really, Daddy? Yeah, I know he did. He did. I didn't think that was you. The old fish tank. Threw it in. All right. How much time are you gonna need this afternoon?
There's just a little bit of information that the people and I need to flesh out, Judge. It's 2 weeks now. 2 weeks should be fine, Judge.
You want the 6th or the 15th? Jeez, oh, Pete.
That's which one?
We've been at this all day. I can just Oh, now you're gonna ask him?
The 6th is fine, Judge.
The 6th?
Yes, Your Honor.
Okay. May 6, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case People versus Cynthia Lake Pier.
Good afternoon, Your Honor. David Chan, Cynthia Lake Pier.
Ma'am, your name?
Cynthia Lake Pier.
Thank you.
Your Honor, you should have a plea form in front of you there.
I do. Plea form indicates that she's going to be pleading that there are going to be 2 counts added. Count 3 of operating while intoxicated, the 93-day offense. Count 4, resisting and obstructing attempt, the 1-year offense. On her successful plea to that, those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Has she signed an advice of rights form?
She did. Should be in the file. We did the last time we were here.
First one.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
To
State your name.
Cynthia Lake Pier.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
The first charge is that of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir.
All right. Count 4 is the charge of attempted resisting and obstructing an officer. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, ma'am, that while I'm taking the plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, sir.
All right. Now, understanding all of that, you still wish to plead guilty?
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of these offenses?
Yes, sir.
January 18, 2025, at the location of 9876 Main Street, Whitmore Lake, Northfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
Captain and Coke at Captain Joe's. I don't remember. Maybe.
All right. Were you stopped by the police or was there an accident?
There's a single car rollover accident, Your Honor.
Okay. Did the police arrive?
Yes.
Were you taken to the hospital?
Yes.
Was there a blood draw?
Yes.
And what were the results of the blood draw?
It was 0.253, Your Honor.
Ma'am, do you have any reason to dispute those blood test results?
No, sir.
All right. When the police did arrive and you were interacting with the police, what happened?
Did you attempt to kick one of the police officers?
Yes.
And at the time that you were attempting to kick the police officers, what were they trying to do?
Take me into the hospital.
They were trying to get you into the hospital, get help for you, and you tried to kick them. Is that correct?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
16th at 9 a.m. before Judge Shower.
June 16, 2025, 9 a.m. before Judge Fresh Hour. And we'll continue.
Regarding bond.
Yes.
There is a key corrections report, maybe slightly concerning. How I read it, there was a missed test in the evening and then the following morning, a late test with a very low alcohol, 0.006, I believe, which.
What happened? I don't know why they didn't say this is a violation of a progress report.
I had just received the,
Mr. Allen, on April 11th, you tested positive for alcohol.
Your Honor, this was the first time she's ever been on any type of sober link monitor. It's the first time she's ever had a criminal offense. And this was the very first day. You can see she missed the test on the night of the 10th, which is the same day she picked up the sober link. And then she missed the next morning, or tested positive the next morning in the 5 to 8 window of the next morning. I believe it was just a process of her getting used to being tested.
I don't know what that means.
It means that alcohol is the undisputed heavyweight champion of the world. If she was drinking prior to that date, she had quit, and she may have still had some residue left over. She has had no positive tests since the first day of testing. And if she hasn't figured out a way to stop drinking successfully, she is going to be found out when she's either continuing on bond or when she's on probation. And we would have no objection to her continuing on the sober link as long as Judge Fresh Hours thinks necessary.
Well, except for the fact that I have an arraignment occurring in January 2025. Unless that date is wrong.
There was she was doing testing, random testing every week for 3 or 4 months, but there was no alcohol testing, regular alcohol testing. There was no sober link. There was no scram tether. There was nothing for 3 months.
Yeah, but she was under an order not to consume alcohol.
I understand, Your Honor, and I'm not saying that she did. I'm saying that it looks like this was her first time ever on a sober link. And maybe it takes her a while or took her one day to realize what the expectations were. And she cannot have any alcohol of any kind to consume anything that would possibly cause a positive reading.
She knows she's not supposed to have alcohol.
I did not. I had a root canal. I was in the process of that. Only thing I had was penicillin. Honest to God.
Is that what you really want to tell me?
I'm telling you the
If
honest
you're,
to God.
no, ma'am, is what you want to tell me is that on April 11th, you tested positive on a sober link because of a root canal?
I had no alcohol.
I've been doing this a minute.
I had
And
no
if that's what you
alcohol.
want to tell me, ma'am, I'm just asking you a straightforward question. Is that what you want to tell me?
Yes, sir.
Okay. Well, then I'm going to let Judge Freshour handle her bond, but at this point, her bond is revoked. Defendants remain.
Thank you, Your Honor.
Court does call the case. People of the state of Michigan versus Mitchell Marion.
Ready, Your Honor.
APA Rachel McDuffie for the people.
Yeah.
Joe Simon on behalf of Mr. Marion. Mr.
Well,
Marion.
there goes that good.
I'm here to restore it.
Is that what it is? Okay.
Yeah.
Oh,
State your name.
Mitchell Marion.
thank you. And what are we doing?
We have a resolution, Your Honor.
Is there a plea for him? I don't see. Ah, there it is. Yes, I have a plea form that indicates that the defendant. What's happening with count 2?
There will,
I'm sorry. do you want me to place it on record?
please.
Mr. Marion is originally charged with 1 count of resisting and obstructing. Count 2, I believe, is a regular OWY. Mr. Simon requested an offer. I was able to grant that request. That offer is that he can have the attempt RNO, which is the added count 3. He would still be pleading to count 2, but there wasn't actually a way to represent that on the plea form. So that count 2 is not going anywhere with the dismissal of the original.
Is he pleading to counts 2 and 3 and
Yes.
dismissal of 1?
Yes, and count 3 will be under the prosecutor's deferred sentence program.
That's what I have. Okay, so I just need. He pleading guilty?
He is. And just to be unequivocal, the deferred is only to count 3.
I mean, you need to sign it.
Oh.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Mitchell William Marion.
Sir, it is this court's understanding you're going to plead guilty to 2 misdemeanor charges. Is that correct?
Yes, Your Honor.
First is a stated count 2 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Court could order community service or any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. And also that you'll be pleading to an added count 3 of attempted resisting and obstructing an officer.
Yes, Your Honor.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand all of that?
Yes, Your Honor.
All right. So you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, Your Honor.
and because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
February 23rd, 2025 at Marion Road near Michigan Avenue in Saline Township, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had liquor and I believed it was only 3 or 4, but it was probably more than that.
Were you stopped by the police or was there an accident?
I was stopped.
What were you stopped for?
Speeding.
All right. You're not disputing the right of the police to stop you in this case, are you?
No, Your Honor.
Were you ultimately arrested?
Yes.
Were you taken to the hospital or to the police station or both?
Both, Your Honor.
Okay. At the hospital, was there a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
0.166.
Do you have any reason to dispute those blood test results?
No, Your Honor.
When you came into contact with the officers, what happened?
I pulled away from the officer and I did not obey his command.
He was trying to arrest you at that point?
Yes.
And it was a Michigan State Trooper that you did that to?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be June 10th, 2025. I'm sorry, 9 a.m. before Judge Freshour. Bond continue.
Thank you, Your Honor.
Thank you, sir.
Outside.
Court calls the case of the people versus Matthew. Is that it for you, Mr. Stoney?
Your Honor, I told you I was here to restore your good mood. There's only one today.
Wow. I am happy.
Next week may not be.
Yeah, I hear you.
Jeremy Glick on behalf of Mr. Matthew Newton. Can you state your name for the record?
Yep, Matthew Newton. Thank you. All right, you're requesting an adjournment.
Yes, Your Honor.
How long did you need?
After May 16th, Your Honor, he has an assessment scheduled with Mr. Statman on May 16th.
16th?
Yeah.
That objection, probable cause will be May 22nd.
Thank you, Your Honor.
Thank you, Your Honor.
25, 9 a.m. Or as your invite indicates. Okay?
Thank you, Your
Bond
Honor.
continue. Thank you, sir.
Have a good day.
Court calls the case of the people versus Michelle Lavas.
Lavas, Your Honor.
Wow, 2 days in a row.
Sorry?
2 days.
2 days in a row.
Don't see you forever and then 2 days in a row.
Yes. I'm sorry. Thank you. John Shea, Your Honor, with and on behalf of Ms. Lovaz.
And you're requesting an adjournment.
We are, Your Honor. This is the first PCC. It's a pretty intensive discovery case, and we're still going through the stuff.
Gotcha. Will the 22nd work for you?
Yes.
Probable cause conference will be adjourned May 22nd, 2025, 9 a.m.
Thank you, Judge.
Bond continues.
Thank you.
Court calls the case of the people versus Sadie Fadro.
Alexander, on behalf of the people, Your Honor.
Excuse me, I'm going to go outside. Michael Vincent on behalf of Sadie Fodero.
Say your name.
Sadie Fadro.
Fadro.
And again, we need a prelim exam date, and I like to adjust bond at the time.
And all discovery is.
Yes.
People have their witnesses available to 6.
We'll do our best, Your Honor.
Preliminary examination in person, February 6th, 2025. That's going to be Dan.
Yes.
At 12 noon. That's before me. As to bond.
Yes, right now, Ms. Fodero is not allowed, oops, excuse me. Thank you. Go to her home on 590 to 590?
Yeah.
590 Bagley as a result of these charges. However, we have been informed, her father and stepfather, Chris Fry, who is here, was informed that the accuser in this matter has moved out of the house. The house is empty. Ms. Fodero has a 4-year-old and a 2-year-old who would love to go back home. Mr. Fry is here to testify under oath regarding a text message.
But the individual that would be testifying is not the individual who resides in the premises. Or is
He
not the
he
victim.
had been living there. He has now moved out. The house is empty.
And Your Honor, we have not received any confirmation from him or anyone that he has moved out as of today.
I have a witness I can bring forth to testify, Your Honor.
Well, but this witness, what's the relationship of this witness?
It's stepdad to my client who got a text message from the gentleman who's accusing my client of domestic violence and what all.
Yeah, I can't do anything with that. Has the people heard from the alleged victim in this case at all?
We have before, I don't know if we've heard from him before this hearing today, but we did before the last PCC hearing. We haven't had any confirmation that he's not at that address anymore. So I don't know.
Well, until we get that confirmation, Mr. Vincent, I'm sure you can understand. I mean, I get the position that your client's in, but I'm not going to change that condition.
I am reluctant to contact this gentleman. I don't like doing.
I know, and that's fine, because what's really gonna have to happen is they're gonna need to communicate to the victim's advocate or the prosecutor that they're no longer at that address. That's typically the only way
Yes.
that I'm taking it.
I would appreciate it if they would proactive contact. the
I
gentleman.
think Ms. Zenda is probably all over it already, even before you got all those words out.
It's pretty fast.
Yeah.
Well,
Okay.
All right.
So at this point, bond will continue with its condition.
Thank you.
All right, thank you. Court calls the case, People versus Zane Huckabee.
People.
Good morning or afternoon, sorry. Sometime. Charles
Yes.
Noe appearing on behalf of and with Mr. Huckabee.
All right, I have a plea form.
That's correct, Your Honor. The defendant is going to be pleading guilty to added count 4 of operating while intoxicated, second offense, 1-year misdemeanor with mandatory minimum 5 days in jail, as well as currently charged count 3, open container in a motor vehicle. In exchange for pleas to those counts, count 1, operating while intoxicated, third offense, and count 2, driving on a suspended license, will be dismissed. This plea is made with the understanding that the defendant has been screened and accepted to the Lenawee County Sobriety Court already, and he'll be entering into that at some point. I did discuss with defense counsel that generally what we do in Washtenaw County is allow someone to be sentenced by their respective district court, in this case, judge, not sure which judge, it'll be 15. And then he'll go from there into Lenawee County Sobriety Court. There are no other agreements.
Is that a correct statement, counsel?
It certainly is.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
State your name.
Zane Huckabee.
All right. Sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor charges. Is that your understanding?
Yes.
The first is the charge, the stated count 3 of open intoxicant in a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs, community service, and substance abuse screening. You understand that, sir?
Yes.
Okay. The other charge is the charge added count 4 of operating while intoxicated, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a mandatory minimum of 5 days in jail. Court could also order, could also order court costs, could order you to pay the cost, could order community services as well as any rehabilitative services. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Moore in the 15th District Court.
Yes.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes.
To the charge of open intoxicant in a motor vehicle, how do you plead?
Guilty.
To the charge of operating while intoxicated, second offense, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of these offenses?
Yes.
I know. On the date of November 3rd, 2024, location of North University near Fletcher Street in the city of Ann Arbor, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
Do you know what you had and how much?
Vodka and 4 or 5 shots.
All right. Were you stopped by the police or was there an accident?
I was stopped.
Well, why'd the police stop you?
Driving without headlights.
All right. Are you disputing the right of the police to stop you in this instance?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital
Yes.
for a blood draw?
Yes.
What were the results of that blood draw?
0.228.
0.228.
Yes.
Do you have any reason to dispute or contest those blood test results?
No.
Had you previously been convicted of operating while impaired on October 15, 2019 in the 79th District Court and or operating while intoxicated on or about December 17, 2021 in the 2A District Court?
Yes.
On that date, when you were stopped, was there open intoxicants in the motor vehicle?
The prior, not this case around the prior one, you mean?
No, I'm talking about this case. Was there
Yes, there was.
Was there alcohol in the
Yeah.
vehicle? What was it?
Vodka.
Vodka? What was it in a container?
Yes.
It was in the bottle?
Yes.
Was the seal broken?
Yes.
Did you know that it was broken?
Yes.
Was it yours?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
The people are satisfied.
The court certainly has and it would be proper.
All right, court will accept the defendant's plea to guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
April 25th, tomorrow at 9 a.m. It's the only day that I have.
tomorrow.
Yeah.
That's the quickest I've ever seen.
How did,
That's the day they gave me.
for this week?
Yes. And I double checked what we went over. And it was for 25th.
I think that Judge Moore generally has dockets on Friday mornings for these types of cases.
Okay, but there's a lot of those coming up.
Tomorrow.
And I know she's listening. Here she comes.
Would you like me to contact him?
Yes, thank you. Have a seat. We'll get you a new date.
Okay, thank
All
you.
right,
Judge.
that actually will. All right.
Do we have to go back on the record? Can I just get that from the clerk?
Bond will continue. We'll get you a new date.
Okay.
And you don't have to come back.
Thank you, Judge. In bond, we did present the court with a bond stipulation to amend bonds.
Yes. And
So my client can go to South Korea for work.
We discussed that at the last hearing, Your Honor. The people had no objection as long as the defendant remains testing and compliant with his testing.
Yep, that's why I put the clause in there, all the terms remain in full force and effect.
Okay, that'll work.
Okay.
We're good.
So no sentencing tomorrow, right?
We're gonna call.
Okay.
Yeah.
All right, we'll figure it out.
And we'll just pick a Friday.
Yeah, we'll figure it out.
Right, we'll figure it out. All right,
Okay.
but you can get that from my staff.
That's what I'll do. All right. All right.
Thank
Thank you. Thank you, Your Honor. Nothing further.
Court calls the case, People versus Michael McClure.
And good afternoon, Your Honor. Joseph Hall appearing for and on behalf of Mr. McClure, who appears by Zoom without objection. Mr. McClure, if you could please state your name for the record.
Michael Thomas McClure.
Thank you.
All right, what are we doing?
Your Honor, at this time, I've discussed the options with my client, and after being fully advised, he desires to waive his right to a probable cause conference and proceed to the circuit court.
Into a preliminary examination?
Yeah, yes, Judge. Thank goodness you're here.
I know, I speak Joe Hall, so I know what that meant. All right, sir. Sir, you're waiving your right to a preliminary examination?
Yes, sir, Your Honor.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense is alleged or the offense alleged was committed and that you committed it.
Yes, sir, Your Honor.
And you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Hall.
Your Honor, at this time, my client would waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 25th at 1:30 before Judge Conlon.
June 25th, 2025, 1:30 before Judge Conlon.
Thank you very much, Your Honor.
Thank you. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Thank you, Mr. McClure.
Thank you.
Court calls the case, People versus Matthew McGill.
Jacob Kennedy, Your Honor.
Joe.
Good afternoon, Your Honor. My name is Randall Lewis, and I am standing in for Miss Parisa Sadrina. And that is with Mr. McGill's consent, and he consents to have this hearing by Zoom. Is that correct, sir?
Yes, sir.
Okay, and state your full name for the record, please.
Matthew McGill.
Thank you, Your Honor. We're here for two, we have to address two issues. The first is the competency report dated March 21st, 2025 by Dr. Margot Gilbert at the Forensic Center. I believe that both parties are stipulating to that report at this time and await the court's finding on the issue of competency, which is authored at the end of the report.
And they are indicating that he is competent to stand trial at this time. Is there any additional evidence from the people?
No, Your Honor.
All right, the court, after review of that report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and object of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent.
As to
And counsel, what you will need to supply to the court an order on competency.
We will, Your Honor. Thank you. As to the preliminary hearing, Your Honor, at this time, we've executed a waiver, and that was sent to the court this morning by Ms. Sadrina. And my client waives his right to have a preliminary hearing in this case with an understanding that the matter is going to be bound over to circuit court for further disposition.
Is that correct, sir?
Yes, sir. That is
all right.
correct.
And you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand you'll not have that hearing. You'll proceed to circuit court for final resolution of this matter. You understand that?
Yes, sir, I do.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
As to arraignment, Your Honor, my client stands mute and waives a formal reading of the charges.
Defendant every way formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial in this matter will be set for
June 25th at 1:30 before Judge Conlon.
June 25th, 2025, 1:30, Judge Conlon.
Your Honor, thank you very much.
Thank you. Bond will continue. Have a great day, guys.
You as well.
That's it for me today. Appreciate you.
All right. Court calls the case of People versus Spencer Norton.
Good afternoon, Judge. Jeff Perlman on behalf of Spencer Norton.
Mr. Norton.
I believe my client was on Zoom.
I don't. You haven't? Spencer Norton. I did not have him, counsel.
Judge, would it be possible to waive his presence? We're requesting an adjournment of the PCC.
I don't waive the presence unless the people agree, and I don't think they are given this.
I would ask to approach, Your Honor, but I can't do so in this format. I'm actually not going to agree to waive his presence. I believe, was he authorized up here on Zoom as well today?
I don't know. I'm assuming he was he?
Yes, so I'm not, for that reason, he had easy access to court today, so I wouldn't be waiving his presence. We were planning to adjourn, but I'll leave that up to the court.
Judge, if the court's not in agreement, I just ask to pass the matter briefly so I can get him on.
I'm running out of time in this block. I got a big hearing in front of me, but I'll pass it. But you got about 4 cases to find your client.
Thank you.
Court calls the case of People versus Kennedy Braddock.
Richard McDuffie for the people.
David I. Goldstein appearing on behalf of the defendant.
Kennedy Braddock.
Thank you.
What day?
Any Friday.
May 28th, you're
Told you, I should have just picked one.
May 28th, that was the date yesterday.
Yeah, exactly. If it was Emily's choice, that's what it would have been. All right. Okay, what are we doing in this case?
Your Honor, I was going to ask the court to set a preliminary examination, but that's going to depend on an answer from a question I have to ask Ms. McDuffie, okay?
Oh, boy.
Okay, when we were here last week, I asked for videos and I did get some videos. What I got were body cams. My question to her, and you may not know, is are there any store videos?
Well, Mr. Goldstein, I'm not sure because you actually had Ms. Douglas last week. I had a
Oh,
potential.
so you're right. I'm sorry.
I had a potential offer for you. Why don't you go ahead and turn that green sheet in and we can go from there.
Okay.
Okay.
All right, Your Honor, I'd like her to check and see if there's going to be any,
So we're adjourning.
Yeah.
All right, how long is it gonna take you to check?
2 weeks, Your Honor.
You want the 15th or the 6th?
15th, please.
Cause conference adjourned, May 15th, 2025, 9 a.m. or as your invite indicates, bond will continue. Thank you, ma'am.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Antoine Pitt.
David I. Goldstein appearing on behalf of the defendant.
Mr. Pitt, come on. It's your case. State your name.
Antoine Pitts.
Thank you.
Your Honor, I've requested an adjournment in this matter, and I'll let the court know why. Again, there were videos that I requested. I did get them. However, they're coming on a new platform directly from the Michigan State Police, and we're having a lot of trouble getting them to download and open. So I'm still working on that. So if you were to ask me, do I have all the discovery, I'd have to say no.
No. Got it. Okay. Probable cause conference, May 15th,
Please, Your Honor.
2025, 9 a.m. or as your invite indicates, bond will continue. Thank you.
Your Honor, there is one quick matter on this bond. When bond was set in this matter, he was ordered to test at community corrections. He was already testing for probation. And he's asked me to ask.
Probation.
He's on probation to Washtenaw County Circuit Court, Your Honor.
And my job is like on me about it.
So he's basically testing twice.
How often are they testing?
Once a month.
Once a month?
Yeah.
But it's testing here, the frequency is 1 time per week.
Yeah. I don't want to get fired though, Mr. Simpson.
Pardon?
I don't want to get fired though. I gotta keep calling off my job. I gotta have a job.
This is a drug possession offense, Your Honor, with the relatively recent date of offense. And so, Your Honor, we do believe that the more frequent testing is appropriate at this time.
What was the alleged drug of choice for him?
Cocaine.
Got it. And you're working?
Yes.
I'll send over an order. I'm gonna reduce this testing. Young man, if you mess this up.
I'm not.
I know, people tell me that all the time. So just listen to me. You mess it up. Mr. Goldstein to tell you, I'm not gonna be listening to a lot. You will go. You hear me?
I understand.
So I'll reduce this testing to once every 2 weeks. So I'll cut it in half.
All right, thank you.
Thank you, Your Honor.
All right, that way at least he'll have 3 tests. He'll have 3 tests in a month.
That's right.
Get 1 down there.
Instead of 5, and that's
Right.
That's great. Thank you, Your Honor.
Thank you.